increasing the reimbursement amount of money that the Secretary of Corrections may make to inmates for losses for personal injury or property damage or loss caused by negligence, and requiring notice to the Secretary for claims exceeding the reimbursement maximum. And with that, a bill brief from the reviser.
Thank you, Madam Chair. House Bill 2212 amends KSA 46920. This is the statute that authorizes the Secretary of Corrections to reimburse inmates under the Secretary's jurisdiction for any personal property or personal injury or also loss to personal property that was caused by the negligence of the state or a state agency or any employee of the department. Current law in subsection A provides that no reimbursement payment shall be made on any claim for an amount of more than $500. This bill would increase that maximum to $750. And it also requires an inmate to provide notice to the Secretary of the nature, time, date, and place for claims exceeding $750. However, failure to provide that notice would not prevent the claim from being considered by the Joint Committee on Claims Against the State. Claims exceeding the maximum amount provided for in KSA 46920 are submitted to the Joint Committee. You can see the statutory reference there in KSA 46907. This bill doesn't amend that, but it's included just for your reference. And I can take any questions.
Thank you. Committee questions? All right, not seeing any. Then we will invite our first proponent conferee to the podium, Susan Humphreys, Kansas House of Representatives, District 99. And welcome to committee. Please introduce yourself.
Thank you, Madam Chair. Susan Humphreys, State Representative for Far East Wichita and Andover. And this bill is really something that is it's not going to make any headlines, but I feel like I need to explain it just a little bit. I've been the past chair of the special claims against the state. I've been the vice chair. Next year I'll be the vice chair again. We switch off House and Senate. What that committee does is when a person feels like the state in some way, they need to make a claim against the state agency, and they have gone through every avenue, their final move that they can make is to make a claim against the special claims against the state committee. And so we hear claims that are from $2.50 because they lost, their subscription to TV Guide, up to millions of dollars for some sort of personal injury claim. And about 85% of our claims come from inmates who are in the Department of Corrections. So the committee, if right now there's a limit of $500 that the Secretary of the Department of Corrections, if anything is $500 or below, they can hear that themselves. They make a determination themselves. And then if it's still, if the claimant still believes that they've been aggrieved, they can still make the claim to us. But what's happened is they've come straight to us instead of going to the Department of Corrections first. We hear all about it. What happens is we get on the phone with residents of our correctional institutions, and there's 7 members of the House. Okay, first of all, I want to stand up and put my hand over my heart when I think about this committee. What other country or maybe state do inmates get to talk to members of the House, the House and the Senate? So anyway, that's beside the point. I make that point all the time. But we listen to them, and we 90% of the time reject their claim, but they do get heard. Sometimes if there's been some issue of negligence, then we pay the claim. Okay, but what happens is if they have not gone first through the Secretary, then it comes to our committee, and we have to dismiss it for them to go back to the Department of Corrections. It's just it's a time element. So by raising it to $750 and saying in here that they must that they have to provide notice to the Secretary, it keeps the special claims against the state from hearing so many claims. So it's kind of a time saver. That 500 limit was, I think, around 20 years ago or so. We didn't get the exact number of years. Just needs to be raised to 750 to make it more clear. Anything under that, the Secretary themselves can take care of. If it's over that, it will go to the special claims against the state after they've given notice to the Secretary. That, I know I went on a little bit about it, but I always try to make a plug for the committee, and with that, I'll stand for questions.
Having served on the Special Claims Against the State Committee, that was a very good explanation of how it works. So thanks for your service on that committee as well. Are there any other persons in the committee meeting room or on WebEx wishing to testify as proponent on the bill? Not seeing any, then we'll go ahead and open it up for any questions. Senator Reichman.
Thank you very much, Madam Chair, and thank you very much, Representative, for bringing this bill forward. It's good seeing you again. I remember the first time I saw you, you says, you're sitting in my old seat in the House.
Yes, nice to see you.
When you're hearing these different stories and whatever, and we're moving it up to 500 to 750 for the claim, I wonder if you give us a little bit of background. Why did you come up with 750? And that was just kind of like I want to know why you came up with that number.
Yeah.
Thank you.
That's a very reasonable question. Thank you for that. It's just that when we looked at how long it had been since it had been raised, it seemed like a reasonable amount. We didn't want it to be too much, but it needed to go up a significant amount, and 750 just seemed like the right. The committee, so the Special Claims Committee made this recommendation for a bill, and that's the number that they came up with.
Okay, thank you. And if I'd like to follow up. So when you hear these different claims, could you give us some examples of what are some of them that would be in that you could take care of if you go up to 750? Thank you.
Absolutely, it's really interesting. Often when a resident in the correctional facilities has an altercation, they have to go to isolation, and so they have to pack up all of their things, put them somewhere, and then they go to isolation, and they could be there for days or weeks or months. When they come back, all of their things are unpacked, and it's not that unusual that their MP4 player's missing, their tennis shoes are missing. They have food items that they bought from the canteen, those are missing. And so sometimes it's just a matter of when they packed them out, did they make a complete list? When they brought it back, were things missing? So we hear a lot about tennis shoes and MP4 players, and sometimes jewelry, glasses. It can be such a variety of things.
Thank you, committee. Other questions? Senator Haley.
Thank you, Madam Chair. Thank you so much. And I want to say to Representative Humphreys how grateful I am to see this bill come forward. I've been a longtime member of the Special Claims Against the States, and for decades have been concerned about the very issue that Representative Humphreys has brought, the accountability of the department and the ability to pay out for these who, as she has so more ably described, what's happening. I didn't even know this bill was working for, but I'll say this, Madam Chair and members, I've asked over the years that something be done about it, various chairs, and now the chair of the Special Claims, Chair Humphreys, having brought finally just a glitch in the system that really is inefficient. When you have all of us sitting around the table, staff and what have you, hearing a claim for a couple of dollars for a missing MP3 player or sweatsuits or whatever was taken during the inmates because of a custody issue, that she is finally, as the chair, moving forward. And I'm excited, just wanted to augment and say publicly how much I appreciate seeing leadership step up over a longstanding concern and problem and finally get something done.
Thank you.
Thank you. So with the increase in the bill, it would actually increase the claims that would be heard by the Secretary of Corrections, not by the Special Claims Against the State Legislative Committee.
May be able to take care of those under 750, and so fewer would probably come to.
Instead of under 500.
Yes, exactly.
Thank you. Any other questions? All right, not seeing any, then thank you very much for your testimony. It's good to see you. Absolutely, appreciate it. Are there any other persons wishing to testify as neutral or opponent on the bill? Not seeing any, then we will go ahead and close the hearing on House Bill 2212. Next, we will open the hearing on House Bill 2371, amending the Kansas Revised Limited Liability Company Act, the Business Entity Transactions Act, and the Business Entity Standard Treatment Act. And with that, a bill brief from the reviser.
Thank you, Madam Chair. House Bill 2371 is what is now our almost annual, it seems like, update to the various limited liability acts to conform with, primarily to conform with Delaware law on this matter. As originally introduced, the bill would have just brought Kansas law into conformity with Delaware. The House Committee on Judiciary added the contents of House Bill 2355, which is a bill about series limited liability companies. You'll see the bulk of those changes, I think actually almost all of those changes are in Section 16, and I'm sure they're going to be highlighted by the conferees on the bill. I'm afraid if I get too more technical than that, I'm going to lull you into a mid-morning nap, and you are about to hear from some of the most prominent attorneys in the state on this issue. So I'm going to let them get into the details, but if you do have any specific questions for me, I can take them.
Thank you. Could you point out where the House Committee amendment starts? You said Section 16, but do you have the pages?
Yeah, so if you start on page 30.
Oh, I see page 30 now. Yep.
Yeah, that's where Section 16 starts. And then the items that are bold there are additions from that House bill.
Okay, great. Thank you. Are there any other questions for the reviser? All right, not seeing any. Appreciate it. Thank you. And our first proponent conferee will be Clayton Barker, Deputy Secretary of State, General Counsel Office of the Kansas Secretary of State. With that, please introduce yourself and welcome to committee.
Thank you, Madam Chair. Clay Barker, General Counsel, Kansas Secretary of State, and we are in support of the General LLC Improvement Bill. Our office was part of the Kansas Bar Association Corporate Group's working task force on this bill, and I'd like to compliment them. They have spent months going through this line by line. It has professors and practitioners, and you're going to hear from them that are going to get into the content of the bill. The Secretary of State only has one provision that was added to the original bill, and that's all I'm going to limit my testimony to that, and that is the provision about fees that we're able to charge for LLC filings. And currently, to form an LLC in Kansas or for a foreign LLC to come into the state, the entity must pay $150. That's set in statute, no ability to change that. And we would simply like the ability to reduce that by regulation. So a ceiling of $150, but we can charge less. And in comparison, corporations, when they form, the statute says $150, but it can be set at a lower amount by the Secretary of State. And this is so we can try to get all our fees essentially the same for the same action, regardless of the type of entity. And I should make sure to be full disclosure, those formation fees go to state general fund. They don't go to the Secretary of State. And about 29,000 LLCs form in Kansas every year. So if we were to reduce the fee to make it consistent with other similar filings, the SGF would see a reduction in the amount coming in. I don't think it would be incredibly large, but just so the committee's aware of that. And Madam Chair, that's all the testimony I have. You'll be hearing quite a bit from either Mr. Quick or Mr. Matthews on the meat and contents of the bill, but I'll stand for questions at the appropriate time.
That would be great. Thank you. If you'll wait until we're done with proponent testimony, then we'll open it up for questions.
Thank you, Madam Chair.
Thank you. Next, we will hear from Eric Stafford, Vice President of Government Affairs, Kansas Chamber. Please introduce yourself and welcome to committee.
Hi, Madam Chair and members of the committee. Good morning. Eric Stafford with the Kansas Chamber. Let me get to where I need to be here. Thank you for the opportunity to speak in support of House Bill 2371. We were kind of a late party to this and had some changes made in the House that put us in support. Specifically speaking on series LLC provisions. Others did the heavy lifting that we'll be talking after us, so they're the real brain power behind all of their changes. But the provisions that we were looking at, I think the best explanation that we heard from, or that I heard when we were working on this is, if you think of a series LLC as a condo building and each unit is an actual LLC underneath the main entity. That is the purpose of the Series LLC structure, is to kind of streamline licensing provisions, and the changes that we were asking for on the House side were really to add clarification and just be a little bit more, in our view, clear. It wasn't a simple or easy discussion by any means, but ultimately the committee did adopt and the House did pass the bill with the language that got put into the bill. But really, as we dug into this, there was a lot spoken, and a lot of the history and time and effort that gets put into the focus on Delaware as like the main corporate state and business state to follow. But there are becoming a series of court cases that are coming out of there that are quickly turning Delaware into a not as friendly business state. And you're seeing some companies transfer their corporate filings to other states, Nevada or Texas, Utah, et cetera. So Kansas is a kind of a mix of Delaware, largely Delaware, but also has some Illinois series language. The language that was added on the series LLCs largely reflects Missouri, which Missouri was based off of, I think, largely Illinois series LLC language. But ultimately, with that language put into the bill, we are a proponent. We do appreciate the insight and opinions of those who have been working on this with the Bar Association, but would ask for your support of House Bill 2371, and I'd be happy to answer any questions you guys have.
Thank you. Appreciate it.
Sure.
If you'll stand by for questions after
Sure.
all the proponents. Thank you.
Yep, thank you.
And next we will hear from William Quick and Bill Matthews on behalf of the Kansas Bar Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair Warren. My name is William Quick. I'm an attorney at the Polsinelli Law Firm. I also am the chair of the Kansas Bar Association's Kansas Revised Limited Liability Company Act Study Committee, which proposed the omnibus revisions to the Kansas Revised Limited Liability Company Act that are before us today, at least in their original form. A number of other individuals serve on that committee. Bill Matthews, William Matthews with the Folston Siefkin firm, who is also remotely present today, is on that committee. Clay Barker, who spoke just a moment ago on behalf of the Secretary of State's office, as well as Jameson Beckner with the Secretary of State's office, participated in that committee. Professor Amy Westbrook from Washburn Law School, Rebecca Miller with the Central National Bank, and Professor Alex Platt with University of Kansas Law School were also on the committee. So I appreciate the opportunity to testify on behalf of House Bill 2371, amending the Kansas Revised Limited Liability Company Act, the Business Entity Transactions Act, and the Business Entity Standard Treatment Act. As you will note, I mentioned three different acts in my ramp up because there are a number of different places that statutory provisions impacting business entities are found in the Kansas statute. In our committee, during its review process, which we do on almost an annual basis, is taking into account how specific revisions made in one part of the statute are impacted and impactful on other parts of the statute on a holistic basis. So it's a very thoughtful process, a very deliberative process, a very fulsome process. So I want to start off, and I can sense, even though I'm online, I can sense the yawnings about to begin. So I'm going to keep this very short. I'm going to start with a little bit of the backstory of the business statutes in Kansas, because I think it's important and impactful on what you're looking at today. And then I'm going to give a lightning speed review of the provisions in the act, because I'm sure everybody except probably Mr. Stafford, Mr. Matthews, and myself probably, will never have this impact their lives. But we care deeply about it. So first of all, the importance of the Delaware law. Kansas, approximately 50 years ago, made a decision that it was going to follow Delaware's business laws on a policy basis. And the reason for that is Delaware has a very unique system set up within their state. They are in spite of the reports of its death, it's still alive and well, is still the gold standard in the U.S. They have a specific process involved in their state. They also have their own courts of chancery, which hear business law cases. So they have a specialized judiciary that reviews business law cases. Most states, the judiciary is not, well versed in business law. Delaware, they have a court that's all they do. So Delaware has what I think most people in the business community would agree is, kind of the preeminent law on businesses, whether it's corporations, limited liability companies, limited partnerships, statutory trusts, series, other various permutations of business entities. And they, on an annual basis, have their legislature go through and consider and make proposed revisions to their statute, which is, a body similar to ours, but, more a larger group that goes in to address the various issues that have come up over the prior year. And they propose, legislative fixes to glitches in their statute and keep it well-tuned, oiled, and operating efficiently. We as a state do not tend to have as many cases litigated about business issues and don't have as many business entity formations and don't see as many of the issues that Delaware does. So by generally staying as close as we can to Delaware while taking into account our policy positions that may differ from Delaware, we get the benefit of Delaware's expertise, legwork, interpretation of the statutes through the litigation process. They have a very, large and robust body of case law that interprets their statutes. We have very little case law that interprets our statutes. But we do have a judiciary that defers to what the Delaware courts have done to a large degree. So it's a huge benefit to Kansas to stay as close as we can to what Delaware is doing in most instances. Obviously, there are some limited cases where we will make a choice and we deviate from Delaware. As I mentioned earlier, our proposed revisions revise the Business Entity Transaction Act and the Business Entity Standard Treatment Act. Kansas, a number of years ago, made a decision that we were going to kind of bundle those two types of issues into a separate act that works across all of the business entity statutes in Kansas, whereas Delaware kind of treats those independently in each of their respective business entity acts. So there's some mechanical differences between us and Delaware in that regard, but the substantive aspects, remain pretty consistent. So with all that wrap up, let me get into some of the provisions that are contained in the proposed bill made by the Kansas Bar Association. And Bill Matthews is available to address any issues that may come up with respect to the series aspects of the act in particular, but he's also well versed on everything else. So we feel free to ask him any question you want. But let me, I'll quickly speed through. I think there are about 17. Oh, good news. Only 14. There are 14 topics of revision. So let me get to those now. So we added some defined terms. We defined the term document and the term electronic transmission. The Act previously made use of the term electronic transmission, and it was defined in a part of the Act, but not in the definition section. We moved that to the definition section because of the prominence of electronic transactions in electronic records. And you say, well, why do we need to define document? Well, up to this point, document was kind of an understood and assumed term, so much so that it didn't even have a definition. Well, now we've included a definition so that it's clear that document includes, in addition to paper documents, an electronic transmission. The second category, the series limited liability companies, we have made some revisions that follow some changes that Delaware has adopted in their act regarding series limited liability companies. Delaware has adopted a model where they have kind of a bifurcated approach. They have protected series and registered series. Kansas has adopted what is equivalent to the registered series concept, and our provisions, track with that and have updated our internal provisions to conform with what Delaware's done in that regard. So, as I said, that helps us, have some reliance on Delaware precedent whenever we have issues in dispute in Kansas. Third, we have void and voidable actions. We have expressly stated that those can be ratified. Mandatory indemnification. We've made some changes to the mandatory indemnification provisions that in large part correspond with revisions that we made to the Kansas General Corporation Code, mandatory indemnification provisions, when we last revised that part of the code. So these are somewhat conforming changes with the corporation statute. We have stated that there are no statutory appraisal rights unless you put them in your operating agreement. There was a little bit of ambiguity in the statute previously on that point. The merger and consolidation language had some clarifying provisions included. There were some ambiguities that were clarified under the division of a limited liability company provisions, and a division is effectively kind of operating a merger in reverse. So you have one limited liability company and you're able to bifurcate and split out different parts of that one entity into separate LLCs. That's a provision that is found in Delaware and Kansas law. Very few other states have that provision. It's a very useful provision if you're a practitioner. There was some clarification on records access and what information, the term information means. There were delegation of powers and conflicts of interest provisions that were updated. There's a statement that subscriptions can be made irrevocable if it's so stated in the subscription documentation. Subscription is where you are entering into a contract to buy securities of an entity. As Clay Barker mentioned, there was a cap on Secretary of State fees so that they could charge $150, but they can charge less if they want to charge less. There were changes to the statutory public benefit limited liability company sections. That's kind of like similar to a public benefit corporation like Ben & Jerry's or Patagonia are examples of statutory benefit corporations. We have some provisions that allow limited liability companies to have similar structures. There were some amendments to the merger timing, which cleaned up some kind of technical glitches and problems that can come up in the merger process, having to do with when a merger is authorized and when documents can be filed with the Secretary of State to affect the merger, particularly anticipatory filings. And then last, and maybe least, we had some provisions that updated the provisions having to do with registered agents to clarify that when an entity is a registered agent, what they need to do and how they can participate in a conversion or division of that entity. So that ends the prepared materials I have. I'm happy to answer any questions you might have, and happy to have Mr. Matthews join in to the extent he has some thoughts on any questions as well.
Thank you for the thorough review. Appreciate it. Mr. Matthews, did you want to testify as well? If so, please introduce yourself and welcome to committee.
Good morning. My name is Bill Matthews. I'm a partner with the Folston firm in our Wichita office. The only thing I guess I would add, as prefaced by Mr. Stafford, is that in the House Judiciary Committee, there's an amendment added at the Chamber's request that made some amendments to the series provision of the statute that aren't from Delaware. They would be the only provisions in that section that actually deviate from the corresponding Delaware law. Our committee opposed those. If you care to hear about the reasons behind that, I certainly would be happy to talk about it. But I think our point is that on the whole, we urge passage of the bill. It contains, lots of helpful provisions to our courts, to our agencies, to our practitioners in our state, and of course, and most importantly, helpful to our businesses. And so, notwithstanding our differences, on those kind of points in the series provision, we urge the committee to pass the bill.
Thank you. Are there any other persons wishing to testify as proponent on the bill? Not seeing any, then we will go ahead and open it up for any questions. Senator Bowser.
Thank you, Madam Chair. I think I have a question for Mr. Barker, please. I generally support this bill. Anything we can do in our state to improve the business environment, I'm all for that. Anything we can do to set the conditions that make business successful in our state, again, I support that. I just want to make sure I have the fiscal note right on this. I thought I heard you say potentially reducing fees, 29,000 LLCs per year. Maybe we go from $150 to $100. If I did my math right, if we gave them a $50 discount and they're 29,000, that could be a $1.4 million fiscal impact. But if I look at the supplemental note, it says no fiscal impact. Can you help me understand the fiscal note a little bit better on that? Is there going to be a fiscal impact or not?
Please go ahead and reintroduce yourself.
Sure, Senator. Clay Barker, General Counsel for the Kansas Secretary of State. Just a little background. So our office has spent 5 years replacing its antiquated software system to allow for much more efficient online filing. And I have on my desk a large packet of regulation changes to eliminate or lower fees in multiple areas. And we're waiting to see how certain bills play out in the legislature this year to see what we have to complete before we submit that. On this particular provision, again, in comparison, corporations, we are told ceiling of 150, lower it if you want, and for corporations, it's $75 to file, for profit, 20 not for profit. And we've asked in a different bill the same permission for limited partnerships, which only about 80 get filed a year, to go from a ceiling of 150 to, or a fixed 150 to a ceiling of 150 or lower. For LLCs, we're asking the same, and I realize that would have a much bigger impact. The reason there's no fiscal note is because two reasons. One, it doesn't affect our office. And second is because we're not sure what we would lower the fee to. We can all do the math, 29,000 times whatever dollar reduction. And in the past, when we've ever lowered a fee that affects SGF, we talked to the Department of Budget, and we mentioned it to the legislature so they know it might be coming. But the idea, again, is to make all similar filings have approximately the same fee, so you don't have a large difference between a corporation or an LLC. I hope that answered your question, Senator.
Thank you. Senator Klemp.
Thank you, Madam Chair. I think my question is for either Mr. Quick and Mr. Matthews. So having a handful of LLCs and going through that process historically, the spirit of the adjustments are under the creating a more continuing with the pro-business climate that we currently have. And I do agree that the gold standard is Delaware. So it's kind of a two-part question. The first is this to remain competitive with the pro-business climate? And the second would be, are we looking at, most recently, Nevada, which is extremely pro-business, in how they handle their LLCs. I was curious if we're always looking at other states and how they're trying to adapt and become more competitive in the space of the business climate. So those are it's kind of two questions there. And
So
let me throw real quick. The last part of that would be to explain the kind of more of a layman version of the serial and maybe a real life example of how those changes would come to what those changes would do.
Please go ahead and reintroduce yourself as well. Thank you.
This is Bill Quick, and I'll let Bill Matthews answer on the series question you had. But I will say this: so the last time we did what I would call an omnibus proposed revisions to the Limited Liability Company Act was in 2019. So it's been about 6 years. It usually in alternating cycles we will do the Corporation Act and the Partnership Act. So it's to ease the burden on our committee, we try not to take on everything every year. So there's a little bit of lag. I will say, one of the first, questions and issues that is presented at the beginning of each of these cycles for our committee is, hey, do we still think Delaware's the answer? Are there other laws that maybe have better provisions, or are there aspects of other laws that we may want to include in our statute that aren't based on Delaware? And we do pick up those other nuances from time to time when they make sense for our business community. We want to be very pro-business. We want Kansas open and available for businesses to thrive. So yes, we do look at the other acts. We affirmatively decided Nevada was not the best option. And at this point, deviating from Delaware was not the best option. Can that answer change in the future? Yes. I think there's been a lot of hype about Nevada and Texas, and there's been a lot of noise from some loud people with a lot of media coverage. And they, because of their personal issues, didn't like Delaware. But it wasn't because Delaware wasn't good for business and didn't have good business statutes. It's because they got some unfavorable court rulings in Delaware that they didn't like. So I don't think that our, jumping ship to Nevada or Texas or some other model or creating our own is a very sound business approach. But yes, that's one of the things our committee does in analyzing this. And we've got, I guess I'm an adjunct law professor at KU Law, but, we have two full-time law professors that are on here that, that's their bread and butter and livelihood is staying up to date on this. So, we definitely approach this from as many angles as we can. It comes from the academic perspective. It comes from the Secretary of State's boots on the ground perspective. It comes from, legal industry, law firm practice, comes from, the banking community. It comes from the chamber. We take in a lot of information from all of the constituents that are impacted by this in Kansas to try and come up with the best result. So I feel like maybe I've gotten a little too long-winded there, so I'm going to stop. I don't know if I answered both of your first questions. If I didn't, please ask again.
You absolutely did, and I appreciate
Okay.
that. You're correct on the court rulings probably was driving a little bit of the energy in Delaware. Yeah.
This is Bill Matthews. Again, I'm happy to address the series question. I would like, though, to jump on a little bit with Mr. Quick's response. Corporate and business law is, as Mr. Quick described, a cottage industry in Delaware, and Delaware is absolutely committed to being at the forefront in the area of business law, which again is another great reason why we model Delaware. I mean, the issues that have been highlighted in the news recently are at the forefront of the minds of Delaware legislature, its legal practitioners, and its business community. And as a matter of fact, there is a bill currently introduced in the Delaware legislature only last week that is on the fast track to address these sorts of issues. And so, I mean, Delaware is going to figure this issue out, and we get the great advantage of taking, being able to, in effect, copy all the hard work that they do to, help properly balance our business entity laws that take into account all aspects of business, not only management of companies, but also investors. We do not want our state to be overly hostile to investment capital. And if our system becomes unbalanced and investors see Kansas or other jurisdictions as being hostile to their interests, well, that means business won't thrive in Kansas. And so we're obviously going to take a look at that, not being on the bleeding edge of these changes, but being able to take into account, all the business input and learning to take a balanced approach that provides a overall business friendly climate. So to address your question about series, so series admittedly is not at least yet, a super popular option or variation in business entity statutes. But in Kansas, and in a growing number of states, I think that there are 21 or maybe 23 states so far have adopted series provisions as part of their LLC statute. And the sweet spot of a series provision is, think of it as a kind of a division within a limited liability company that can have separate assets, can have separate owners or members, can have separate managers, and the sweet spot is that, in effect, there are complementary aspects of an LLC's business that can be conducted separately through a series, but yet governed by uniform rules through a common operating agreement. So where I, in my practice, see series considered most option are things like companies that commonly do investments, and they might want to have separate funds with separate investors to manage different investments. So they will have a separate series for each of those kind of investment or portfolio vehicles. The other place that I see series considered most often in my practice is where there might be different assets that the LLC and its management and owners would like to have different liability shields associated with it. So we see a lot of like real estate investment companies that have large real estate portfolios might put their various separate real estate assets into different series to kind of help manage that liability. But admittedly, this is not yet a super popular option for most businesses. But yet its adoption among the various states is growing. Delaware was the very first state in the nation to adopt this concept, and it's slowly been catching on. And most notably, about 3 years ago, the Uniform Law Commissioners adopted the Uniform Protected Series Act. And so, there's now been like 3 or 4 states that have signed on to that act. So it's there's greater interest over the last several years in that concept.
This is Bill Quick. Don't hold me to this, but I want to say there are about 22 states that have series statutes or series aspects in their limited liability company acts at present.
Thank you. Did you have a follow-up? Okay. Thank you. Senator Rose?
Thank you, Madam Chair. Are there any tax advantages for businesses that set up as a series LLC? And to add to the 22 states that are currently doing it. What about the states in our region, our surrounding states? Will this help Kansas compete against states in the region? And does Kansas need to make any changes to our tax structure to add fuel to this fire?
Well, again, this is Bill Matthews. The statute itself is neutral as to the tax treatment of series. That is a matter for the revenue statutes for the state and the Internal Revenue Code of the United States. That I kind of think is outside of our purview. I'm by no means a tax expert, but I generally understand that under the IRS proposed regulations, not finalized regulations, that series by kind of it depends on the particular facts and circumstances about how they're set up, but generally series are taxed in one of two ways. One is they in effect are treated no differently than the LLC in which they were a part, and so they're kind of disregarded and all the tax consequences roll up to the series, and the series is taxed the exact same way as the LLC itself is taxed. The other main concept is that that depending on the facts and circumstances, the series could be taxed separately as a separate legal entity, and then it follows just kind of the same default rules about how LLCs are taxed. The default being that they're taxed as partnerships unless they specifically elect, through an election through IRS filings to be taxed separately as a corporation. So no, as designed through the LLC Act, there is no special tax consequences one way or another about how LLCs are or should be taxed, and rather we see that as a separate policy discussion, among for the tax laws and the committees that deal with those issues.
So Senator Rose, this is Bill Quick. I would add to that. This is an area that people frequently get kind of confused or have a misunderstanding. The federal tax treatment of a business entity is wholly separate and apart from the state law juridical person attributes of the entity. You make a separate tax filing with the IRS to establish, or if you don't do anything, there are certain default rules for the federal tax status. The state law income tax status generally follows the federal law status of that entity. So as far as income tax attribution, it is independent of the state law entity status of the business entity. It is quite frequent that the two kind of operate in tandem, so people understandably misunderstand that the two are tied together, but they're not. So I will say this, any limited liability company, whether it has series or not, you could actually have multiple federal tax entities within that limited liability company or partnership structure by having different people with different economic rights in filing independent tax filings to establish separate federal tax entities within that limited liability company. That also can be the case with series, or it might not be the case. It all depends on how you do your federal tax filings. Hopefully that was as confusing as it seemed.
Thank you. Any other questions? I have just a few. Yes, Mr. Barker wants to add something. So sure, please reintroduce yourself. Thank you.
Thank you, Madam Chair. And just for the committee for context, in Kansas, as of a week ago, there were 170,000 Kansas LLCs. Only 329 have actually had series. Think of it as parent children. And there are about 24,000 non-Kansas LLCs, and only 329 have, 217 have series. So it's a very small group that actually use these series. I just wanted the committee to have the perspective there.
Thank you, appreciate it. So if I'm reading the bill correctly, the only sections of the bill that are truly new and not amending current law are sections 1 and 2. Is that right? And section 1 seems to provide on page 2 that, starting at subsection C, regarding delivery and receipt of electronic transmissions that are defined in that new subsection, that unless it's otherwise agreed between the parties or in the operating agreement, that the default position in Kansas will be, if this bill becomes law, is that the electronic transmission is delivered when it's sent, and it's delivered on per line 22, even if no person is aware of its receipt. So this would be wholly new Kansas law. And do any other states treat electronic transmissions delivered when sent and delivered even if no one is aware of its receipt? Is that generally how other states do it, I guess is my question. And is that something that other states do?
This is Bill Quick. I would say Delaware does that.
So, Mr. Quick,
I don't have a holistic list of all the states that do that. I will say that there currently are provisions for electronic transmissions in our existing act. And the reason this is a new section and not showing up as a revised section is we have stripped out the reference to electronic transmissions that were separately dealt with in different subparts of the LLC Act, and instead dealt with them through the creation of these defined terms in the definition section.
So we're only aware of, for certain, that Delaware treats electronic transmissions are delivered when sent and delivered even if no person is aware of its receipt.
At this moment today, I can't really speak to that. I know there are electronic transmissions acts at the federal and state level that deal with these issues.
Okay, well, we can have research kind of follow up on that. That'd be great.
So this is Bill Matthews. I can speak to this a little bit. So this provision is copied directly from Delaware, a new provision that they adopted a couple years ago. And I will also say that it corresponds to a very similar section that we added, again, from Delaware to the Kansas General Corporation Code. So that was passed like two sessions ago in Kansas. And this was to modernize the business entity acts related to electronic documents, electronic signatures, and electronic notifications. And so that particular provision, although stated in general terms, the most apt analogy is by email, right? And so when can an entity provide notice, for example, to its owners, to its members? Or when can a corporation provide notice to its shareholders, for example, of a meeting? And when is that notice given? When is that notice effective? And, think of email, right? So if notice is allowed to be given by email and the company sends an email to its owners of a meeting, and let's say the email recipient never opens their email, they never look at it. Well, has notice been given or not? Well, yes. This would establish the very logical and straightforward rule that if you're allowed to get notice by email and somebody sends you an email and it hits your email inbox, then you've received the notice, even if you negligently or purposefully never open your email inbox and actually look at that email. And so
Great,
that
thank
in effect
you.
is what that provision says.
Appreciate it, thank you. Committee, other questions? Not seeing any. Oh, yes, Senator Bowers.
Thank you, Madam Chair, and this would be for Eric. As you're coming up, I'll just ask, as a business owner of several LLCs, does this bill help me in ways as a business owner currently? Can you say, oh, here's something you should look at as a business owner that we have this new law? We'd like you to see what else you could do, or how would I explain it to LLC owners at home that here's something extra good for you?
I think
Thank you,
those
Madam Chair.
questions would probably be best left for Mr. Matthews or Mr. Quick, as we've only focused on the series. The series doesn't impact you. My wife, who has an LLC, has asked that question. I said, no, this is not applicable. But the other changes, I think it is modernizing the statutes. That's the goal from the Bar Association and the conversations we've had with them. So I think what they've put together is ultimately a good product to help streamline businesses and filings and all that. So yeah, they could probably give you more detail. But yes, overall, I think it's good for you as a business owner.
Oh, good. I only picked on you because of Chamber of Commerce and business owner. So I just wanted to see if there's anything good in here that as a business owner I should just like hop into and look at on a just a regular business owner level. That was my only thought.
Okay, well, if we do have neutral to hear from, can we get that? I think that would be helpful for the committee if we could get kind of a response from either Mr. Quick or Mr. Matthews, and we can provide that to the committee and add that as a committee document if we get that answer. So thank you. If that would be all right with the proponents.
This is Bill Quick. Madam Chair, I'm not sure are you asking for our testimony to be entered, or are you asking me to respond to
or how
Senator
about
Bowers?
just a quick top 2 or 3 items that to answer the senator's questions about what we would tell business owners, LLC owners in Kansas that here's this bill that's potentially new law, and here's how it would help you in your operating your LLC. So we're kind of running short on time. So
I would say there's nothing glamorous in this. These are, tweaks to the inner workings of the statute to make it more efficient and up to date, and to clean up some potential ambiguities that were in there before. I don't know that there's any new specific, Easter egg included in the proposed revisions. I don't know that it would rise to the level of even registering for most business owners unless they have a situation that is on point with one of the changes that were made, and then they would be happy that we made these changes. I will say in particular, like the merger provisions, I was dealing with this last fall with merger timing. Would have been nice to have this change before that. We had to kind of work things out with the Secretary of State's office, and there's kind of a leap of faith in the deal. This would make it clear what the answer would be.
And Madam Chair, other than lowering our fees, would be the other nice business provision, I would say. So I could see that one. Thank you so much.
Right.
Thank you, Madam Chair.
Yes, thank you for the answer. Next, then, seeing no more questions, we will invite neutral conferee Kelly Van Zwal, VP Government Relations, Staff Attorney, Kansas Bankers Association. Please introduce yourself and welcome to committee.
Hi, good afternoon. Thank you, Madam Chair, committee members. Kelly Van Zwal with Kansas Bankers Association. My testimony is actually written, so I'm sorry for the if there's an error there.
You're right.
But
I do see that.
We are neutral on the bill as is, but if you do have a question, I'm happy to speak to anyone later. Thank you.
Sorry, apologize for that.
No worries.
Thank you. Is there anyone wishing to testify neutral or opponent on the bill? Not seeing any, then you do have the written testimony from the Bankers Association at your desk. We will close the hearing on House Bill 2371, and I do have 5 bills that I think we can work today, possible final action, and get through and get everyone out in time so we're not cutting too closely into the lunch hour. The first bill that I would like to bring up for consideration is House Bill 2347, and that's a bill that we heard yesterday about changing the culpability required for certain types of theft, and we were particularly talking about motor vehicle theft. And with that, just a brief summary from the reviser.
Thank you, Madam Chair. House Bill 2347 deals with that culpability standard for theft, specifically the type of theft that's obtaining control over stolen property or services. Right now, that's a knowing culpability standard, and this would change it to knowing or having reason to know that that property had been stolen.
Thank you. Are there any questions for the reviser? Not seeing any. I do have a proposed amendment that I would like to share with the committee, and it's on page 2 of the bill. You'll remember we asked a question and law enforcement answered regarding whether we should keep the status quo of the law, that it's a misdemeanor, or the bill as introduced provided that theft of a motor vehicle with a value less than $1,500 would be increased to a level 10 non-person felony. So what the amendment does is, before it came to the Senate, the bill was amended by the House, and it struck the proposed change to make it a felony. This amendment puts it back in to make the crime a felony, and it also takes into account the testimony we heard from Mr. Klump, or excuse me, yes, Mr. Klump, that well, what about the junk vehicle that has less than a $500 value? So he had suggested making it, you'll see in the bubble, a value of at least $500 but less than $1,500. So we've taken that testimony and proposed the amendment. So is there a second on the amendment? Senator Haley. Thank you. Any discussion on the proposed amendment? Senator Haley.
Thank you, Madam Chair. I greatly appreciate the position that you're taking, and that I hope that this committee will take to evaluate the testimony of Mr. Klump and others for what the deprivation of these items, these cars at $1,500 or so really means, and that we in fact do underscore with the severity level and maintain that as it's been in our law. And I do appreciate your having brought it, and I hope that we'll be able to amend appropriately.
Thank you. I should say any discussion or questions? Not seeing any, then I'll close on the motion, and you all have heard the motion. Those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. We are back on the bill. Is there any further discussion? Bill as amended. Is there any other, is there a motion regarding the bill as amended? Yes, Senator Titus.
Thank you, Madam Chair. I move that the committee pass House Bill 2347 and recommend it favorably for passage.
As amended.
As amended.
Thank you. Is there a second? Senator Bowser, any discussion? Then would you like to close?
I close.
Thank you. You all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. Thank you. Next, I would like committee to take a look at House Bill 2155, and that concerns liability of sheriffs for official acts when they are acting in their official capacity. We heard that last Thursday, February 27th, and a brief summary from the reviser.
Thank you, Madam Chair. House Bill 2155 would specify that those sheriffs have liability for their official, so it'd add the word official before acts related to the charge and custody of running a jail.
Thank you. Committee, any discussion or excuse me, questions for the reviser? Not seeing any discussion or questions, or I'll entertain a motion. Oh, wait a minute, I do have an amendment myself. So that we can get the bill into conference for further discussion with the House, the amendment proposes to change the effect of the law from publication in the statute book to publication in the Kansas Register. And you're probably familiar with this type of amendment on other bills in committee. So I would move that we would amend the bill in this manner. So is there a second? Senator Titus. Any discussion or questions? Not seeing any, then I'll close on the motion, and you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries, and we're back on the bill as amended. Any discussion or a motion? Senator Bowser.
Thank you, Madam Chair. I make a motion that we pass House Bill 2155 favorably out of committee as amended.
Thank you. Is there a second? Senator Klemp. Any discussion or questions? Not seeing any, then would you like to close? Thank you. You all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. Next, I would like to take a look at House Bill 2166. And 2166 we heard Monday, and that's our annual continuing exceptions to the KORA statute. We heard a brief from the reviser. The reviser was the sole conferee on it, and we'll hear kind of a brief summary again from the reviser.
Thank you, Madam Chair. House Bill 2166 is your annual continuation of the open records exceptions. The two exceptions that you're extending this year are in 48-962 related to local health officers, records containing personal information relating to people testing positive and under quarantine orders for COVID, and then 65-7616, which deals with information under the Licensed Acupuncturist Act.
Thank you. Questions for the reviser? Senator Shane.
Thank you, Madam Chair. Ms. Scott, for the exception for personal information relating to individuals testing positive or under quarantine or isolation due to COVID-19, is that same information, would there be exceptions for any other disease which the local health officer might quarantine or isolate someone for?
Madam Chair, Senator Shane, if you turn to page 6 of the bill, you can see KSA 48-962. That was a statute that was specifically put in place related to COVID-19. So the entire statute relates to quarantine orders related to COVID. So this exception would just apply in those certain circumstances.
Madam Chair, if I may, I wonder if that should be broadened to include any disease which the Secretary might quarantine or isolate someone for.
Would you be proposing an amendment then for that?
I would be willing to consider that, and my apologies for being absent when this bill was heard, but.
Oh, that's okay. Well, let's, I guess, any discussion on that? We're not discussing the amendment right now because we'd need it written, but yes, Senator Titus.
Thank you, Madam Chair. I think this would be a separate bill. This is all in the Emergency Preparedness Act, and like I say, it's all tied just to COVID. And while the idea has merit, this is just a narrow thing that I don't think this would be the appropriate vehicle for that.
Well, with that, is there any further discussion on the bill or a motion? Or do you want to, we'll work it another day? Senator Shane?
I would defer to the chair's discretion. I could also look at working on a floor amendment if that would be appropriate as well.
We'll work this, we'll take a look at this tomorrow so we can have that discussion here. So thank you for that. And next, I'd like to take a look at House Bill 2242, which we heard yesterday regarding the request by the federal government that the governor accept concurrent jurisdiction. And with that, a brief reminder from the reviser.
Thank you, Madam Chair. House Bill 2242 would create a process where the federal government people who have control over land that's used for military purposes that's owned by the federal government could offer back concurrent jurisdiction to the state of Kansas. The governor would take those requests and accept those requests, and I can take any specific questions you have.
Thank you. Are there questions for the revisor? Not, yes, Senator Rose.
When we discussed this, thank you, Madam Chair. When we discussed this bill yesterday, I asked a question about should we include any land owned by the federal government? Is that a worthy amendment or not necessary?
Well, the bill is specifically written, and it says, I don't recall at which line, but for military purposes. So maybe that would be a different bill to take a look at, but I appreciate the discussion and that the question was asked, and this would be just for the narrow purposes of our military installations here in Kansas.
Sounds good. Thank you, Madam Chair.
Thank you. Any other discussion or questions? I do have an amendment that would change the effective date from publication in the statute book to publication in the Kansas Register. Is there a second? Senator Titus. Any discussion? Not seeing any, then I'll close on the motion, and you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. We're back on the bill as amended. Any question, discussions, or a motion? Yes, Senator Titus.
Thank you, Madam Chair. I would move that the committee pass House Bill 2242 as amended and recommended favorably for passage.
Thank you. Is there a second? Senator Rose. Any discussion? Not seeing any, you may close. Thank you. You all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. And the last bill I would like to take a look at today would be House Bill 2062. And we heard that last Thursday, February 27th. And that is providing for child support orders for unborn children from the date of conception. And with that, a brief summary from the revisor.
Thank you, Madam Chair. House Bill 2062 would amend the statute that requires the Supreme Court to develop the child support guidelines to add that those child support orders shall include the direct medical and pregnancy-related expenses of the mother, add some provisions about how those medical expenses are calculated, and then it provides for definitions. And I can take any questions.
Thank you. Any questions for the revisor? Not seeing any discussion, or I'll entertain a motion. Senator Haley.
Thank you, Madam Chair. We heard a lot about this bill. I continue to genuinely harbor some real concerns about some of the changes, certainly not only in the definitions that are found in the bill, but also some of the litigation, the confusion that would come about in attempting to determine, first and foremost, the potential paternity of the putative fetus/unborn child. And so I really don't know if the mechanics of this could work or how it would work, but I am concerned there's a quantum shift, a major shift in what we know to be responsibility that can or should be taken for an actual child. And it just changes the dynamic of how that is. And I really just don't think that the mechanics would be in place for this bill to pass that could be implemented. And I just don't see it in its current form. That's something I could support.
Thank you. A quick question for the revisor. What was the vote in the House on this? I think it's 85 to 34 is answer my own question. 85 to 34?
Yes. Okay. Yes, Madam Chair, it looks like it was 85 to 34.
Thank you. Any further discussion? Senator Corson.
Thanks, Madam Chair, and I won't belabor it, but I continue to have reservations about the fetal personhood aspects of the bill. I've discussed that for the past several years when we've talked about that. Continue to have reservations about putting this sort of language into our statute books. I'm also worried about pregnancy-related expenses just being really, I think, ill-defined or not at all defined, and I think it's going to be open to various interpretations across the state. I think judges are going to have a really hard time coming up with uniform application of what is a pregnancy-related expense, because I think that is something that reasonable people can have very, very differing interpretations of. And then I do worry about this language about the date of conception and privacy and other considerations around that. Related to how we would be asking kind of a non-medical district court judge what sort of evidence a woman would be having to come forward with, and how much of that would be private information in order to have, again, just a district court judge who's a lawyer, not a doctor, make a finding of what the date of conception is. So for those three reasons, I'll continue to be a no on the bill. Thank you, Madam Chair.
Thank you. Further discussion. Senator Klemp.
Thank you, Madam Chair. One of the things we had talked about in the hearing was the date of conception was going to be when the doctor first identified that the baby was in the womb. So I was curious, were we going to adjust that to kind of take away that concern that Senator Corson had, that so I was just more curious where we fell on that, if there's any further movement on that.
I haven't heard that there's an amendment for that, but something that would be left to the court's discretion to determine what that would be. Yes, Senator Shane.
Madam Chair, kind of to Senator Klemp's point, I would think that a judge would discern that the date of conception is the medically determined or medically estimated date of conception, which is very standard medical practice for pregnancy care.
Right, when you establish what the projected due date is, and it's, okay. Thank you. Does that help answer your question, Senator Klemp?
It does, Madam Chair. Thank you.
Okay, great. Thank you, Senator Shane. Further discussion? Not seeing any, and wanted to remind the committee that we did hear testimony that language that recognizes an unborn person is already in Kansas statute in a couple areas of law regarding trusts, I think regarding crime, regarding tort actions for wrongful death of an unborn, and that it would be, just like other child support orders, would be for the court to determine what the pregnancy-related expenses are, to use the judge's discretion. So with that, then, I would entertain a motion. So Senator Rose.
Thank you, Madam Chair. I move that the committee favorably pass House Bill number 2062.
Thank you. Is there a second? Senator Klemp. Any discussion? Not seeing any. Would you like to close?
Yes, I close. Thank you.
Thank you. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. No. The motion appears to carry. The motion does carry. Committee, that's the 5 bills that I had wanted to work on today. Please be sure to get your amendments ready if we have those. And I would like to take a look again at House Bill 2166 tomorrow regarding those continuing KORA exceptions. And with that then, thanks everyone for your attention today, and our meeting is adjourned.